a law that was meant to prevent coercion has become the reason of fear. That is exactly what has been said against anti-conversion laws to Supreme Court, and Supreme Court has issued notices not to 1, 2, 3 but to 12 states and union government to seek answers on this very important constitutional balance which is drawing sharp scrutiny. Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to understand that why Supreme Court has issued notices to the states, what answers they are seeking on anti-conversion laws, what are the constitutional provisions around it which are related to balance, and what state might end up doing and saying in this context. So let us begin with understanding that why exactly Supreme Court is looking into anti-conversion laws. Because when we are talking about a law that is related to legislature, legislature is responsible for creating laws. When we are talking about judiciary, they do not take legislation into their hands. But why they are looking into until and unless there is something constitutionally wrong with it. So the reason here is that there has been a challenge that has been raised, and this challenge has been raised by National Council of Churches in India. Now these petitioners are saying that the anti-conversion laws which are meant to avoid any coercion, any fraud in this context, they are going beyond preventing forced conversion. What do they mean going beyond? They are saying they are being misused, and this misuse is for targeting religious minorities. Now that is why this case is raising a serious question not just about fundamental rights but also the rule of law and how there is a misuse of state of power. So we will be trying to understand all of this, and in this context first we will be starting with what exactly are anti-conversion laws. So let's just say whenever there is a matter of religious conversion, that means one person is changing his religion from this to that, in that context anti-conversion laws come for regulation. Why regulation is required? Because there is a possibility that the conversion might be because of force, fraud, inducement, because of money or any sort of allurement, and state does not want that because this is against fundamental rights. So that is why anti-conversion laws have been made. And in this context, we get to see that most of the state have mandatory prior permission or post-conversion intimation. That means the states have to be informed if the religious conversion has taken place. In some states, the rule is about prior permission, that they have to tell the state and the state will permit, and sometimes the provision is of that after the conversion has happened, the intimation needs to go to the state. And another thing that has been seen related to anti-conversion laws is that if the conversion has happened, the burden of proof is not on the individual but on the person who has facilitated conversion. That means a person at a certain social level, be it a pastor or any such a relevant position, who has facilitated this conversion will be the one who has to prove that. And in case the proof is not valid, if the proof is not concrete, then the penal provisions are not just of arrest but also imprisonment, and state believe that this is very important to ensure that there is proper public order and there is social harmony. That is why this particular law is important. Now in this very context, we have to move on to the other side also, where now in this particular context, Supreme Court has issued notices to 12 states including Uttar Pradesh, Madhya Pradesh, Gujarat, and then we have Chhattisgarh, Rajasthan, Odisha, Karnataka, then Himachal Pradesh, Uttarakhand, Haryana, Jharkhand, Arunachal Pradesh, and also to the union government, specifically to Ministry of Law and Justice. That means this is not only related to rule of law, fundamental rights, misuse of state of power, it is also related to constitutional significance and balance which is present, and it is going to affect across India. That means this is not a state-centric thing, it is not a local dispute, rather it is a constitutional clarity that is required at the country level, and that is why this particular challenge becomes all the more important. Now moving to yet another dimension associated with it, understanding the other side, that what exactly are petitioners saying incentivizing vigilantism. So petitioners of this particular challenge, they are saying that the design of the law, anti-conversion law, it is flawed. How it is flawed? It is flawed because it encourages misuse. As per these laws, any individual can file a complaint. Let's just say the conversion has happened anywhere else, but any other person can go file a complaint. There is no requirement of first-hand evidence. There is no requirement of immediate evidence, and the police action and the arrests can take place immediately. So that means in case there is an innocent person involved, there will be no evidence against him, but he will be arrested, and then the proceedings against him will begun. So as a result, we are seeing that there are many scenarios where we have seen false complaint, harassment of pastors, social workers or minorities where the conversion has taken place, and in this vigilant groups have taken a huge role where they have decided to do the moral policing. They are the ones, they have decided that we will be incentivizing this and we will be responsible for being the moral police. And that is why when anti-conversion laws, this is what petitioners are saying, when anti-conversion laws were meant to actually give a safe environment in terms of ensuring that there is no fraud, there is no coercion, rather they have created a climate of fear and they are not bringing any justice. Now, all of this is directly relevant to multiple constitutional provisions such as Article 25, which gives you a fundamental right to freedom to profess, practice and propagate your own religion. Article 14, which talks about equality before law, which talks about arbitrary arrest, violates this principle. Now, in this context, what petitioners are saying, yes, these constitutional provisions seem to be violated. Article 21, which talks about right to life and personal liberty, that there should be no arrest without proper safeguards which affects liberty. And that is what petitioners are saying, that anti-conversion laws are imposing unreasonable restrictions which are not based on constitution, and they are violating these rights, and this is going beyond what is permitted under public order, because reasonable restrictions can be made on fundamental rights, but only if it is affecting public order, and they are saying this is going beyond public order. Now, when we are looking towards state's defense, what they might say in that context, we do have certain precedents, because when we are talking about fundamental rights, there is no fundamental right to convert another person. Furthermore, forced coercions disturb social harmony, and that gives a ground for reasonable restriction. Similarly, Supreme Court has a clear precedent set where they have said right to propagate does not mean right to convert by force. And that is why states also have a ground to justify the anti-conversion laws under public order, morality and also health, because it is allowed under Article 25. But one question that still remains in the front, that there can be more clarity and probably lesser misuse of law that can be ensured, and that will come only in the picture when we get to know are these laws reasonable and proportionate. So what are your thoughts on this? Let me know in the comment section. Supreme Court, when we are talking about in this regard, we also have to understand as of now Supreme Court has not stayed these laws, because that was the main demand of the petitioners, and Supreme Court has also admitted this matter for constitutional scrutiny because there are multiple constitutional provisions around it. And that clearly indicates that this issue is not only serious, but it is also rights oriented. So the answer of Supreme Court will be another precedent which will bring in more constitutional clarity, which will have clearer definitions for understanding and protection of minorities and ensuring that rule of law stays intact and in the very right place. And these are the certain dimensions and themes that are important from the perspective exam, making this case important, that how there will be always a trade-off between fundamental rights and state power, how we need to balance religious freedom with minority protection, how judicial review and constitutional morality come in picture and play a very important role in a democracy like India. And an important keyword and theme is vigilantism. Now let me know your thoughts on this in the comment section. That was all from my side. Thank you so much.